Yeah.
You're live.
Thank you. Welcome, everybody, to House General and Housing. We're reconvening after a short recess. We are going to hear testimony on S 125, which is an act, Senate omnibus labor bill that has come to us. We have quite a bit of testimony today, and we may be taking testimony beyond this morning. Our first witness will be Steve Howard, who is Executive Director of the VSEA, the Vermont State Employees Association. Steve, you want to come up?
Sure. Morning, everybody.
Steve, you have testified here before, correct?
Yes,
So you know the committee.
I do. Thank you for the opportunity. I in here, I didn't bring cookies because you wouldn't want the cookies that I would make. But I did bring a handout, which I think is better for your health.
Steve, is this something that we could have an electronic form
Yes.
so we can?
Tom is sending it right now.
Great. And so are you sending it to Magali?
I will.
Okay, and that way it can be posted.
So, Mr. Chairman, thank you for the opportunity. My testimony will be very, I think, short and sweet. Although that's the danger of calling a bill a simple little bill on the floor means you're going to be there for the whole day of interrogation. So I may have just jinxed myself. But I think VSEA wants to weigh in favor of S 125 as passed by the Senate. We worked very closely with the Senate Committee on Economic Development in an extensive discussion of the bill. And we would urge this committee to pass the bill as it was passed in the Senate. We are looking for a clean bill without a lot of changes. That would be our preference. There are two provisions that are really important to us. One is the provision that would allow employees in the judiciary to have an election to vote on whether they would like to become part of a supervisory unit. Right now, we represent about 200 members on the front lines in the judiciary, and there are a group of supervisors, mostly courtroom operation managers and potentially some supervisors in the call center who have expressed an interest in joining, at least having a vote on whether they could be part of the VSEA or any union. And that is consistent with what has been true of the executive branch for decades. In the executive branch, we have both a non-management unit, a corrections unit, and we have a supervisory unit. So you can work in corrections, but if you're a supervisor, you're in the supervisory unit. You're not in the corrections unit. You work in the non-management unit. You may be a supervisor in an executive branch agency, but supervisors are in one unit and the rank and file are in another. And so the judiciary, our members in the judiciary would like to set, at least have the option to vote on whether they could have a similar structure in the judiciary.
Steve, before you go on, I just want to go over one thing you just said. So there is a supervisory unit in corrections.
In the executive branch, there is a supervisory unit, a non-management unit, and a corrections unit.
So in the executive branch, I'm sorry, I just don't know this. In the
Sure.
executive branch as a whole, there is a supervisory unit, or is it just correction?
It's the entire executive.
Branch.
Yeah, all supervisors are in the supervisory unit.
And in the executive branch.
In the executive.
That doesn't cover the judiciary.
Exactly.
Is that, are there other major exclusions?
No, the only exclusions in the executive branch would be somebody who is classified as an exempt employee or a confidential employee.
Yeah,
Otherwise, they would be in the bargaining unit.
in the bargaining
Yeah,
unit.
they'd either be in the non-management unit, the corrections unit, or if they're a supervisor, they would, regardless of where they work in the executive branch, they would be in the supervisory unit.
So this is in order to give supervisors in the judiciary branch a chance to petition to be a bargaining.
Exactly. Yes.
Um,
Can I piggyback?
yeah,
real quick?
other questions on, or were you about to, well, go ahead.
Whatever you want to do.
Yeah.
Sorry. So if you're exempt, you're automatically, you cannot join?
Exactly. If you're an exempt or a confidential. So an exempt position would be somebody in the statutes listed as an exempt.
Yeah.
So it's mostly political appointees. There are other exempts like legislative staff currently is listed as exempt. But it's there. If you're not in that category, you're in a bargaining unit.
Never mind. I got it. Sorry, I was thinking exempt and exempt versus non-exempt and salary versus wage. So I was like,
Yeah, that's really confusing.
Well, yeah, that doesn't make sense to me, but
Yeah.
sorry,
Yeah.
I'm now with it.
Yeah.
Please ignore me.
So,
Thank you, Steve.
so exempt means you're a political appointee, legislative staff.
Yeah, or you're confidential. There are some folks who are considered confidential, and those folks are staff that would have access to information that would put them at an advantage, or it could put the union at an advantage, or the administration at a disadvantage, because they have access to data around salaries and all that stuff. So those folks are confidentials, and those are mostly like the commissioner's principal assistant is generally a confidential. Most of the employees in the Department of Human Resources are considered confidential.
So people who have a conflict of interest just intrinsically.
Exactly. Those folks are set aside.
Other questions? Are you about to move on?
I am, if you're ready.
Well, that's what I want to know. Is there anyone else who has a question about the supervisory, the ability, the part of the 125 that relates to supervisory personnel in the judiciary? Other questions from the committee? Okay, Steve, please proceed.
Okay, so that the second provision in the bill that we think is a real priority for our members is the provision that would change the number of signatures required to trigger an election for a decertification. Our members would like to join Hawaii, Massachusetts, and Ohio that have raised that standard to 50% plus one. The current standard is 30%. And for us, this is an important change because 30% in our view allows for the triggering of elections almost on a constant basis. So if you think about your districts, having served in the legislature, I can tell you that at least 30% of my district did not want me in the legislature. Probably more, but at least 30% at all times thought I shouldn't be a legislator. And what happens now under the current law is that 30% can petition to constantly have elections to change representation, or in the legislative context, imagine you get elected to the legislature and then 30% of your district can have a recall to, constantly have you focused on trying to keep your job rather than do your job. So we believe that Vermont should raise the standard to 50% plus one, because we think that if there is to be an election, which is a huge endeavor by the VSEA and by the union, there should be a significant showing of support. It shouldn't be 30% dictating what the union is doing at the expense of 70%. And so that is an important provision that we would ask you to support as well. You'll see in the handout, there's a couple of other points that we would make on that. Right now, you may have heard, and I'm not sure if you've taken testimony on this, but I can attest that the Vermont Labor Relations Board that oversees elections for unions has more on its plate than it can handle. the backlog at the labor board is significant. We have folks who are sometimes waiting up to a year for a decision on even just a grievance. And a lot of the testimony from the labor board has been about the time that they've had to put into various union elections. Now, we want union elections, but we also know that if we're going to have them, there should be a significant showing of support. One thing I do want to just clarify, that this is sort of similar to what you all experience when you run for office. The showing of support is collecting signatures to trigger an election. And then there's an election. And in the election, if you are chosen as the bargaining unit, you have to win 51% of the vote. You don't win 51% of the vote, there's another election until you do. And in that election, there's also the option of no union. So it's usually like 1 or 2 unions, maybe 3 unions competing, and the option of no union. Somebody has to get 51% in order to be declared the exclusive bargaining agent for that unit. So this is akin to getting signatures to put your name on the ballot and then having an election. So it's very similar. And the process is, as you may know from collecting signatures to run for your offices, not everybody who signs your petition ends up voting for you. And some people who didn't sign your petition do vote for you. So there's a big difference between triggering the election and then the actual election that occurs several months later.
I have a good question about the parity in for lack of better terms, I'll just call it a cooling off period. You can't just back to back keep filing 30% over and have elections. There must be some period of, if the unit has failed to garner support, there must be like some period of time before that can process.
Yes.
Start.
Yes, you're right about that. So you can file petitions in what's called the open period. And that is set in statute. It's a confusing scenario, but generally it's the summer. It's 2 months before the first Tuesday of the legislative session. There's a period of time in which you can file petitions. It's limited by the statute, but you can do it in Vermont, unlike many other states where contracts tend to be at least 3 years, sometimes 4 years. Vermont's contracts tend to be 2 years. So you can do it every 2 years. And so that means that you are, as a union, often you get about a year to really do full focus on the work of the union. And then you might very quickly be back into an election process that sort of pushes everything to the side, and you have to focus just on that.
And are those the same for certification and decertification?
The election period, yes, this for certification, it's not, but for decertification, it is. You can file if you're filing cards to create a new unit, you can do that at any time. But if you're decertifying, you have to do it within the open period.
The open period being the period when the contract is.
It's the year the contract is negotiated, and then the formula is based on when the legislative session begins, which is, I don't know how they came up with that, but essentially it means it's that you count backwards from the first day of the legislative session for the number of weeks that the open period is allowed.
Joe, go ahead.
Okay, thank you for that. My next one would be, why the discrepancy now in the 50% plus one, with one automatically certifying and one just creating an election process?
In other words,
What is
why
that?
is there
What happened?
it's asymmetrical, I assume purposely. So it would make it easier to organize a union than to decertify a union. I'm assuming that's purposely.
Well, it's not exactly, it's harder because you have to get 51% of the vote in order if you separate forming a union versus the issue that we're discussing, which is whether to decertify a union, in order to represent that bargaining unit, you have to get 51% of the vote, which is a lot harder than getting just 30% of cards signed to trigger the election. So this makes some parity between what you need to actually represent the unit and what you need to trigger the election.
Aren't we at a 50% automatic? I thought it was 50% now, plus one
That's to form a new unit.
to form a unit.
Yeah, that's separate. That's a separate law than decertification.
But this is, like you said, it's kind of creating this odd weighting scale of, I'm just recalling a year or two ago, whenever it was, this notion that, if 50% of the employees have, more than 50% have decided to form a new unit. I mean, we need to trust those people. They're competent enough to understand what's going on and everything else that was said around that. But now if those same 50% plus one wants to decertify a unit, somewhere along the way, they have lost the cognitive ability that we should trust them and believe in their desire to now decertify.
Not really, because if there's two processes here, so it's the signature collection.
This is for which?
This is for decertification. There's the signature collection, which right now is only 30%. And then there's the actual vote. So in order for the decertification to succeed, you have to get 51% of the vote. So it's the same, basically. It's the language is a little different, 50% plus one and 51%, essentially the same. But the signature to trigger the election is only 30%. So this actually creates a level playing field.
I thought there was no vote if it was 50% plus one.
That's for forming a new unit.
Yeah.
There's a separate law that governs decertification. That law that you're describing does not apply to decertification.
So creating a unit and decertifying a unit.
Right, they're two separate laws.
Okay. Yeah.
Did you have a question or?
I just have a clarifying question.
Yeah,
Is it 51% or 50% plus one vote?
So the proposal before you, to trigger an election, the proposal before you calls for 50% plus one. The current law governing the election is 51%.
So 50% plus one vote, not one
Yes,
50 plus 1%.
right. You got it. That's
No parentheses.
right.
Okay.
I guess did you go ahead?
I do have a question. Not about this, but sort of about this. To certify. 50% plus one. And then is there an additional and then there's an election of different units or different unions to who's chosen? Like who votes on who is chosen?
Sure. So this is how, so let me go through the three processes maybe. So in this bill, right now under the current law, if you want to decertify the unit, you need to collect at least 30% of the bargaining unit, which includes non-members who never joined the union, but they're in the unit. You get 30% of them, which is fairly easy to do, to say they want an election.
Yeah.
Then the election occurs, and that vote has to, the union that becomes the exclusive bargaining agent has to win 51% of the vote. And if you don't win the 51%, you keep going until someone does.
Thank you.
Yeah, it's a little bit like voting for the speaker on the floor. You have to keep going until there's a majority,
But I think it would help me. My understanding, and correct me if I'm wrong, is that the way, if we pass S-125,
Mhm.
that it will be easier to certify a union than it will be to decertify, and that's deliberate. And my assumption was that the reason it's deliberate is because I'm not a labor lawyer. I don't have a lot of background in this, but I have read that there's been a lot of very kind of deliberate attempts by outside groups to sort of foment dissatisfaction with the union and provoke these repeated things. is that right? Am I right?
Yes.
And if so, could you talk a little more about that? I don't know that much about that.
Yes, so our experience has been that there is an active effort to have unions constantly in election mode, which is distracting from our ability to actually do the work of representing our members. To the point of whether it's easier, I think there's two different buckets. There's the forming a new unit where there is no unit. That is easier now because of the law you passed previously.
It's 30% and it can be card check, right?
There's no card check in the D-cert.
No, in the certification.
In the forming new unit bucket,
Yeah,
that's a lot easier because it's just 50% plus one card check. In the decertification,
30% sign up. Isn't it either one?
yes,
Yeah, so
Yeah.
you can get 30% signing up or 50% card check, 50 plus one.
right. In the forming of
In the forming of a union.
in the D-cert bucket, which is a separate bucket, you have the 30% signature to trigger an election. And then the law requires that 51%
Right.
vote in favor of either one of the unions or no union, which is always an option.
Just straight 50% or plus one?
In the D-cert bucket, it's 51%.
So nationally, what's going on, at least by your testimony, is that this is sort of an attack on unions because it's sort of, yeah, it's a way of getting them in a continuous self-defense mode.
Right, and there are a lot of issues that and I'm just speaking from our experience, that are
Are the national or are
just the
the?
VSEA's experience. There are agendas that are broader than just working conditions,
Oh, sure.
pay and benefits. It has become part of a broader cultural phenomenon. And that is, whatever the issues are, it's fairly easy to get 30% to agree with whatever, either they're non-members and they never liked the union in the first place, or they're just part of that group that's like folks in your district who are just perpetually unsatisfied. And they can easily trigger an election for both the cultural reasons and just general reasons that make it harder for the union to actually put the time and effort in it takes to improve wages, benefits, and working conditions. So it makes it harder for the union to represent its members.
Go ahead.
I just have one last question, and I can always catch you offline if there's more to it. What is the history of Vermont having 2-year contracts? Like, why? It sounds like that's not necessarily the norm. Do you know why?
Yeah, and it's certainly not universal in Vermont.
Yeah.
There are some contracts that are longer, but with state government, I don't know what the history is there. I do know from just conversations with our general counsel, who operates in all New England states,
Yeah.
that this is very peculiar, or just not peculiar. I guess that's not the right word. It's unusual. Usually it's 3 or 4 contracts. So, I'm not sure what the history is. I don't know. It's long before my time, but
Wouldn't it be tied to the gubernatorial cycle?
could be. Yeah, I don't know.
It's very short in this
Yeah.
compared to other states.
Something I can do research on.
And so another question I have. You said non-union members can vote
Yeah,
in the decertification.
yes, that's correct.
These are the people who you represent,
Yeah,
you're required to represent
correct.
in the sense that wages, one cannot negotiate a labor contract which says the wage per hour is this, but only for union.
That's correct. Yeah, it's for the entire bargaining unit.
It's really, and the bargaining unit consists of everyone in that, whether they're a member, a dues paying member of the union or not.
That's correct.
And would that continue to be the case under the S-125?
Yes. Yeah. Nobody is compelled to join the union.
And they are represented and they could vote in a decertification.
That's correct. Yes.
Okay. Other last questions? Steve, did you have more?
I just had a quick
Yeah.
one
Oh.
about,
All right, go ahead.
I think that the scenario of having like a really egregious union decision, leadership style in the union or something, and requiring people to wait, till the next election as opposed to having some recourse, right, is basically just trying to understand. So this is what you're trying to still respect that there could be some kind of real issue
Yes.
with union representation that requires a sooner election to be triggered than the regular cycle.
Well, it would be it'd be on the regular cycle still, but it would require a significant showing of support. It wouldn't be the minority 30%, it would be 50% plus one. So if you have an issue where you can get 50% plus one to sign cards, that seems like a significant showing of support that then justifies putting all of the time and energy into that election process. 30% is from our perspective is too low.
Right.
It makes it too easy,
30% of all workers.
Yeah.
right?
And yeah.
Steve, did you want to address anything else in connection with this?
I don't think so. I think I have hit most of everything I wanted to say,
Do
but
you wish to discuss certification? Not certification, what's it called? The part
Payroll
of the,
certification.
what,
Payroll
payroll
certification.
certification and all.
I am going to happily defer to David Mickenberg
Okay,
to
great.
talk about that exciting and
David, that's
interesting topic.
Okay. Any last questions? Here's your chance. Okay.
Thank you very much.
Very much, Steve. Really appreciate it. Our next witness is Joe McNeil here.
Joe McNeil is participating remotely.
Oh.
And you guys are going to present jointly, if that's okay.
That's perfectly fine. So we have Terry
I
Corsone.
don't see him in the room.
I do.
Okay, sorry. Oh, but I know he was here before when the this.
Good morning.
I apologize. No.
Oh, you're good.
Morning.
Great, thank you.
Whatever. That's actually. Yeah, yeah. I was connected and gave him maybe 9:30. So. I didn't see him today, but I'll resend him. Oh, if you are doing that, that might be what I saw. See what's happening. Oh, that's totally right here. Yeah. Okay, my golly's gonna send me right now the link that you need to, up here. So Attorney, oh, I'm sorry. Attorney Joe McNeil is an experienced labor lawyer out of Burlington, but he's in California for work this week, so he's connecting from there. And I did submit a memo that I made copies of that I'll pass out now.
This is Terry. You just want to state your name for the record.
Terry Carson, State Court Administrator, and Attorney Joe McNeil will be hopefully momentarily connecting this way.
Great.
And here is a copy of the memo that I will be referring to part during our testimony. And it's my understanding we have
You want to
minutes, so it's kind of
pass this memo.
sorry about that.
Terry, is this memo available electronically?
I had submitted it to Magali, but I offered to bring paper copies. in case-
Okay, so it's on our website.
Yes.
Great, thank you.
Sure. And I can also, while we're waiting for Attorney McNeil, in response to your question, when you had inquired about exempt employees, it occurred to me that might be helpful to kind of list the exempt employees currently under the statute in the judiciary. And it is more than just confidential employees. For example, and we're just testifying on section 5 of S 125 strictly. And section 5 currently lists those employees who are exempt from the collective bargaining unit. And it includes judicial officers, and that's the justices, superior court judges, magistrates, hearing officers, assistant judges, the court administrator, my office, my division chiefs. And it excludes and exempts managerial employees, supervisory employees, confidential employees, law clerks, attorneys, or administrative assistances to the judge or the court, judge, justice, or court administrator, an individual employed on a temporary, contractual, seasonal, or on-call basis, including interns, an employee during the initial or extended probationary period, the head of a department or division, an attorney for the Supreme Court. For the court administrator, we have a general counsel, or for any board or commission created by the Supreme Court, an employee paid by the state who's appointed part-time as a county clerk. And then also a category of an employee after hearing by the board upon petition of any individual is determined to be in a position that's sufficiently inconsistent with the spirit and intent of this chapter, the warning exclusion. So in my mind, I see it as managerial typically would be exempt. And we do have, of our 400 employees in the judiciary, approximately 240 who are non-exempt, who are part of the bargaining unit. And then the balance are exempt. So it's quite a significant different categories of the total employment. And what section 5 purports to do is to make one word, strike supervisory from the list of exempt employees. And I don't know if, oh, good, Attorney McNeil is on.
So can you
Perfect.
hear us? And if we can see you, it'd be great, but can you hear us? Still, it's not
I
connected.
can hear you fine, thank you.
Okay. So you're testifying. I'm Mark Mahaly. I'll tell you what, I'm the chair, and so, oh, there you are. Okay. You want to introduce yourself as well, so you and Terry can testify jointly?
Thank you very much. My name is Joe McNeil. I'm an attorney in Burlington with the firm of McNeil, Eddy and Sheehan. I have had the pleasure of representing the judiciary in collective bargaining and labor relations since the so-called JELRA Act, the act allowing collective bargaining by judiciary employees was formed. I worked on the creation of that act with the then court administrator. I have also served as the chief negotiator, co-chief negotiator for the executive branch in its collective bargaining with the various unions referenced by Steve Howard during his testimony since approximately 1990. So I have a fairly significant level of experience in the matters that you're dealing with. And I just wanted to inform the committee, if I may, that the exclusion of supervisory employees was carefully considered during the initial passage of what became JELRA. And it was based upon the same approach taken by the Congress since 1947 in the National Labor Relations Act. The National Labor Relations Act, which governs collective bargaining across the country with regard to the private sector primarily, and those involved in commerce, excludes supervisory employees. And from a very interesting historical note, the reason primarily that supervisors were excluded was at the behest of labor unions in the country who felt that they did not want to have their affairs compromised by those who might have a conflict of interest. And the Congress believed that those that have supervisory obligations would have a potential conflict of interest because they are serving two masters. Interestingly enough, the definition of supervisor in the National Labor Relations Act is identical essentially to the current definition of supervisor in JELRA. And that is an individual with authority to hire, transfer, suspend, lay off, recall, promote, reward or discipline employees, or responsibly to direct them, so long as the exercise of that authority requires discretion and independent judgment. That's the definition currently that applies to supervisory employees in the judiciary. And the reason supervisory employees were excluded is that they have the obligation, if you will, they're hired on the basis of using their best judgment, their best experience, their best skills on behalf of their employer, the judiciary. And it was felt, and it is felt still at the National Labor Relations Board under the so-called NLRA, that this remains a credible distinction, and the rationale in favor of it remains strong. It has been supported, endorsed, confirmed by the United States Supreme Court over many, many years. And I would just indicate that Steve Howard is correct that there is an exception in the State Employees Labor Relations Act that does allow supervisory employees to be in a bargaining unit. I'd point out that that is different than the Municipal Employees Labor Relations Act, which excludes supervisors, what's called the State Labor Relations Act, which covers employers in intrastate commerce, not covered by the NLRB or potentially covered by both. That act also excludes supervisors. I wasn't present at the time SELRA was first, I wasn't involved at the time SELRA was first passed. I have subsequently been informed by those that were around at that time that the reason supervisors in the executive branch were allowed to bargain is that there were so many additional layers on top of frontline supervisors, managers, deputy commissioners, commissioners, secretary, and the governor's direct administration, that it was felt that the frontline supervisors in the executive branch had more commonality of interest with the call it non-supervisory employees than with the managers and up. I'll let Terry speak greater to this point, but the judiciary is leaner and meaner, and I don't mean meaner, but its supervisory employees truly exercise a supervisory function. And to dilute that function and create a conflict of interest for them, or certainly the potential for conflict of interest, to serve two masters, the union's interest and the judiciary's interest simultaneously, the judiciary believes would be unfortunate. So, but that is the history, if you will, of the exclusion of supervisors. And as I said, first it was to protect the union, and secondly, it was to protect the interest of the companies from potential conflict of interest. And that has remained the law of the land nationally, and has remained the law of the land in Vermont under the majority of the labor relations statutes that you all have passed over the years. I'm happy to take any questions you may have.
I have a question for you, Joe. It's pretty basic. I imagine there's an easy answer, but this is not a field. This is a field I'm relatively new to. I understand you're saying that the rationale is fundamentally a conflict of interest rationale. That is, it's a sense that supervisory employees, they have to supervise people, and you don't want them having to supervise people that they're in the union with. Why isn't this just taken care of by having the supervisory people in a separate bargaining unit?
Well, it's a good question, Mr. Chairman, and thank you for it. The thinking on the part of the Congress when it passed the National Labor Relations Act, and the legislature when it passed JELRA, was that it unnecessarily and inappropriately divided the responsibilities of the individual supervisor, regardless of whether the supervisor was in a unit combined with non-supervisory employees or in a standalone unit, because the expectation upon hiring is that this cadre of employees will look exclusively to the benefit of the judiciary and will work exclusively for its success. And the thought has been that diluting that responsibility to include, in part, working for the best interest of the union while simultaneously working for the best interest of the judiciary is an attempt to serve two masters simultaneously, and not a good idea.
Thank you. Other questions of Joe before? I'm sure Terry will go on and you'll have a shot at her as well. Terry, you want to go ahead?
Thank you, Attorney Neal. The aspects of the issue that I was going to address have to do with more kind of practical. One, Chair, you had asked if the judiciary had the chance to weigh in on this in the Senate. There had been some indications that this was introduced last session and that there had been no opposition to it, and it had passed out of the Senate accordingly. And I just wanted to clarify that, one, if it were introduced last session, the judiciary was not aware of it. We were not informed of it. We were not asked to testify about it. We haven't actually found any evidence that it was introduced, but there were references to it that it was. I just wanted to clarify that if it had been, we were not asked to testify on it. We certainly would have opposed it if it had been, but we haven't found any record that it actually was introduced last session. When we learned about it this session, when it was introduced in House, in the Senate, Senator Clarkson's committee, just before the crossover, we did ask for the opportunity to testify there. And Senator Clarkson explained that because of the timing, it coming right before the crossover. And because in her committee, they were focused on the assistant attorney generals, whether or not they would join the bargaining unit, that was the focus. She suggested we wait until it came over to the House. And so that's what we did, speaking with Chair Marcotte and with you. And so this is our first opportunity to testify. And we very strongly oppose this. But I just wanted to clarify that's the background. So any references to there being no opposition or to it being introduced last session. I just wanted to let you know the judiciary's position on that. Also, with respect to, it's a single word, striking supervisory from the present bill would have, as Attorney McNeil has explained, would have strong ramifications that would be very inconsistent with labor law in general for decades and in Vermont in the judiciary. We have 4 judiciary supervisory employees, 4. And we're kind of at a loss as to understand why a separate collective bargaining for 4 employees would be logical or make sense, or what the rationale would be for that. I've spoken to at least one of the supervisors who didn't even know that this was being proposed and does not support it. So it kind of leads us to question why it's being proposed. I know Mr. Howard explained that they had had extensive discussions with the Senate, and he was asking that it be passed as is. We have had no discussions, and we would submit that there are, as Attorney McNeil has explained, a whole host of reasons why this would not make sense on the one hand, and 2, we feel would be very inappropriate and would be contrary to tenets of labor law that have been in existence on the national level and on the state level in the judiciary, for decades. The fact that the executive branch has an exception for the supervisory, I don't know. I wasn't also present, in terms of the rationale for that, but the executive branch has 10,000 employees and apparently 1,200 supervisors. We have 400 employees and 4 supervisors. I think it's not apples and apples in terms of looking at the management levels and approaches and the conflicts that are inherent typically when you have even a suggestion that supervisors or managers be part of the collective bargaining landscape. So we just wanted to, again, in our 15 minutes, clarify that this was our first opportunity to comment, clarify that we have just 4 supervisors. And I know I'm speaking with Senator Clarkson. She wasn't aware that that was the case. I don't think it was brought up in the Senate, but to me, that's also a significant factor. And if it's pointed to supervisors in the executive branch as being justification, we would say that there's just a stark contrast between their management setup, the numbers of their employees, the diffuse management apparently that's available there that we don't have here. Our supervisors are as well lean and mean. We have far fewer people, and we need to be able to utilize them to their full roles. And it would be very muddied in my view, and would open the door for many issues. So that's in a nutshell, kind of the basis for our opposition to this, again, striking one word from the present bill that does list all the different exempt employees, and we would urge the committee to keep supervisory employees within that list.
Questions? Could you, since there are only 4 of them, could you tell us what they do?
Yes, one is helps oversee the court security officers. And these are dispersed throughout the 23 courthouses that we have in the state of Vermont to ensure that there's continual coverage. If somebody calls in sick, that they can, have the jury trial, that they can open the door, have the screening. So one is to do with the statewide court security officers. One is in finance and administration. One is in.
What does that person do?
It's an accounting function. Oversees 3 employees. And one who is in the technology services center, again, I think oversees 3 employees, help desk type work. And another one is actually in the Costello Courthouse, who oversees, in the Costello Courthouse, we have court staff versus sheriff deputies for security purposes. And that person oversees the Costello court security officers. And then, did I?
Yes, that 4.
4, okay. Yes, that's the 4. I've only spoken with one with whom I work closely, and I just happened, to say I'm going over to testify. This is something that impacts, is there an issue? Is there something that we're not aware of? Is there discontent? And he didn't even know that it was being proposed. And he said, I would prefer not to have a change.
Any questions? Terry, many thanks.
Thank you for the
Joe,
opportunity. Really
thank you
appreciate it.
for taking time to appear.
Thank you very much, Mr. Chairman.
Great. Thank you, Sarah.
Oh, thanks.
Sarah Mirha, did you wish to testify jointly with anyone, or are you testifying yourself?
One of my members, Judy, is here on Zoom, and so I'm happy to tag team with her if that's not too technologically complicated, but we can also go one and then the other. So,
Judy, would you introduce yourself to the committee? And I think before you do, I didn't do this before, but I do see a few faces in this room that haven't been here before. So why doesn't the committee introduce itself? You want to take it away?
Sure, thank you. Good morning. Sadia Lamont, Loyal Washington District.
Good morning. I'm Elizabeth Burrows and I represent Windsor One, which is Heartland, West Windsor, and Windsor.
and we're matched.
I know,
I wish that's.
Hello, I am Mary Howard and I represent Rutland City District 6. Good morning, I'm Gail Pezzo. I represent Chittenden 20 Colchester.
I'm Debbie Billivan. I represent St. Johnsbury, Concord, and Kirby.
I'm Tom Charlton, represent Athens, Chester, Grafton, and Wyndham.
Joe Parsons, Newbury, Topsom, and Groton.
Lenore Dodge, Essex Town, and City of Essex Junction.
Ashley Barley, Fairfax, Georgia.
And I'm Mark Mahaly and I represent Calais, Plainfield, and Marshfield. Judy, I think it would be a good idea if you introduced yourself as well. And that way each of you, Sarah, we know, and each of you can testify.
Good morning. My name is Judy DeRoche. I'm from Danville, Vermont, so it's close to Debbie Dolgan's area. I work with J.A. McDonald Incorporated. We're based in Middlesex, Vermont. We are a general contractor, primarily working on Vermont Agency of Transportation projects. We've been in business for 50 years, and I've actually worked for J.A. McDonald for 40 years. I've been dealing with the certified payroll reporting for a long time, so that's the focus that I'll be testifying on. And I appreciate the opportunity to be before your committee.
Thank you. I leave it to the two of you how to exactly tag your team.
Great. Thank you, Mr. Chair and committee. My name is Sarah Muirhoff. I'm the Director of Advocacy and Communications for the Associated General Contractors of Vermont. We represent more than 200 construction companies throughout the state, and that is both highway and transportation infrastructure type construction, as well as vertical or building construction. We are here, a bit of a vibe shift from the prior testimony. We're here just for the final section of S-125 as passed by the Senate, the section 9 and 10 pertaining to state construction projects and certified payroll. AGC opposes this language as passed by the Senate. As we understand it, it would require that contractors doing business with the state, particularly for projects in that $100,000 to $200,000 range, would be required to submit certified payroll records on a weekly basis to the state agency overseeing the construction project, and those records would be open for inspection at any point without cause or warrant, essentially, by the Department of Labor. Our stance on this is that this is quite a bureaucratic burden for contractors, especially in this $100,000 to $200,000 range. There has been quite a lot of testimony and kind of consternation over this sum of money and how big of a project is that truly. And I understand that a lot of folks, when they hear that number, just putting in the context of their personal finances, $100,000 to $200,000 sounds like a lot. But I'm here to tell you that in the context of particularly state construction, that is not a lot of money. And so what we would like to see is the state working with particularly smaller contractors for these sorts of jobs and encouraging that sort of relationship with small contractors, local folks who are trying to punch above their weight and work with the state. And that this piece, the certified payroll piece, is yet another bureaucratic burden for them to overcome in order to do business with the state. And it's also, frankly, something that just brings them anxiety. Judy can talk a lot about this. She's an expert in doing the certified payroll work specifically for any transportation projects which receive federal funding. There's already requirements in place through the Davis-Bacon Act at the federal level for work like this. Again, for projects that are much more expensive than $200,000. Judy is a humble person and may not brag about herself, but I will. She's been doing this work for 40 years. And so she knows it in and out, and she knows this process. A mom and pop shop of 10 contractors is not going to have necessarily a CPA on staff. They may not have someone with HR credentials, through a higher education process. That would be intimately familiar with these sorts of processes. It is logistically complicated, and I don't want them to shy away from work with the state, knowing that these requirements are going to be on the line. Even just the kind of chilling effect that we could see from folks not wanting to essentially sign the name. I mean, we see a lot of these shops with, say 10 or fewer workers. Their CEOs will often be Renaissance men and women, and they will wear all of the hats, and they will be buying their materials, and they will be signing off on payroll, and they will be, managing their individual employees. And they don't necessarily, familiarize themselves with these certified payroll processes. They aren't familiar with like the nature of working with the state on these certified payroll processes. I don't want to see us, overly simplify this work and frankly demean the work that people like Judy do, because it is a profession. It is a full-time job. She is an expert, and it is a profession that not every small contractor has the privilege of having someone like Judy on staff to do this. So as a sort of illustration of this kind of range of projects, 100 to 200,000, I took a spin through some recently executed statewide construction project contracts. And I'll be honest, I had a really hard time actually finding a contract that fit this kind of dollar range, because again, it is for state construction, quite small. And so the one that I found that I thought was particularly illustrative, I'll be completely upfront and I'll say that this bill would actually not pertain to this contract because this was carried out by the Department of Forest Service. Through A&R, and there's specifically a carve out in the bill for this. I'm not actually sure why that is, but I just want to kind of illustrate like what this sort of dollar range actually gets you and who does this work. So there was a boardwalk replacement project at the Green River Reservoir State Park in Hyde Park, and this was to make the trail ADA compliant. To do this work, this cost around about $150,000 to replace this boardwalk. And it was carried out by, they're not members of mine, so I don't want to speak for them, but they seem to do fantastic work. They're called Timber and Stone LLC out of East Montpelier. I looked at their website, they have 9 employees. And I did not see anyone on those employees who was HR or payroll or any of that, so office manager even. They were all builders. So I know that this bill wouldn't particularly impact them because it was the A&R work, but that's the exact sort of project that we're talking about here. And that's who we want to see doing those projects, those small projects, or small operations. We want to see them getting the opportunity to do this work as opposed to, large shops, who I represent also, to be clear. But I would just like us to see us broaden the scope of who the state is working with, as opposed to just having relationships with the biggest of the big in the state. So I'll pass it off to Judy from here, but I'm happy to stay in the chair and maybe take questions in tandem with her.
Thank you. Go ahead, Judy.
Okay, thank you. As Sarah mentioned, the AGC of Vermont has a lot of members, and most of our members are involved in this payroll reporting process. What I see, if this rule or law is pushed to small employers or small companies, is they're going to have a big burden and may just choose not to bid on these projects. So that's eliminating work for local companies that I don't think is what the intention of the bill is. Currently, when I'm reporting certified payrolls, we have 14 county rates, 14 different rates for highway projects and 8 different rates that we use for heavy construction projects. As I understand, the prevailing wage rates have been removed from the bill. So I have just a lot of questions about it, is what rates are going to be used for this, or if there aren't any rates, what reporting is going to be used. We currently use a US Department of Labor form to report. So I couldn't find anything in the bill that implies what the small contractors are going to be required to use. Who is it? Is there somebody from each agency that has already been assigned the task to review these certified payrolls? And is there a restitution process if there's not an appropriate rate? But again, that goes back to what rates is everybody supposed to be looking at? The bill indicates that the Commissioner of Labor can review the records at any time. That's a very normal process. I make sure to keep all of our records for at least 7 to 10 years, even though it only says 3. Maybe it's my age, but I still keep a lot of paper. And what I'm just concerned with is who it is that this information is going to be reviewed by, and then what's the process after? What kind of reporting that goes to? Is it a manual reporting, or is the reporting going to require a computer program? What Sarah referenced in a lot of our small contractors, they may not be on a computer yet. You're in a situation where it's a husband and wife team or a partnership team where the husband is out doing the actual work. The wife is home with a couple kids and dealing with that and daycare and everything. So she's doing the bookwork at night and is able to process payroll because you're given from the IRS in the state of Vermont wage withholdings and all that information. So you can very easily do payroll appropriately without a computer. But the way a lot of this reporting is it's much more efficient with a computer. So I know that's a small thing and that a lot of us can't imagine a company working without computerized documents, but you have to consider that for a lot of the smaller folks. And even though we are bidding on bigger jobs, I mean, we really don't do a lot for less than $100,000, but still there's got to be a balance for the smaller folks to be able to do that work. I just worry that mandating rules like this for a small company and these small projects is going to be a big burden to those little contractors, and we don't want to lose them. I mean, it's great there's a lot of us larger contractors in the state, but we still need the little guys out there as support for all of us.
Thank you. Questions? Go ahead.
Thank you, Judy. I do have a few questions. Let me just say, I have worked in HR and I absolutely hate payroll. So God bless you and what you do.
It's a necessary evil. You got to keep your employees happy.
Absolutely. We got to get people paid, but it is the worst. That being said, how long does it take you from start to finish to do certified payroll?
Again, that would be if somebody is in a manual system or a computerized system. Our company, in the peak season, we have about 80 employees. And I have one of my employees, Donna Lacoste, who is our payroll administrator. And that is her function for definitely the summer. I can't have her working with us on accounts payable or accounts receivable or any other projects because the focus is on certified payrolls, being sure people are paid the appropriate rate in the appropriate county for the appropriate classification and verifying that. I would say for a small company that maybe has 10 employees, it would take at least a half a day once you have all the employees' time and you're assuming that you've already got them set up in your system so you can just write a check. And then do you take the USDOL form, which is what we use, which I know it's hard to see that in this, but is there a reporting how is the reporting going to be required to be done? Is it this USDOL form or is it a new form that's created? If it's new, it's hard to guess how long it would take, but I got to say it's at least a half a day of work for, say, 10 employee company to produce payroll and then spend another hour or two writing out this form.
And that would be for somebody who has the experience of working on payroll, not just somebody who, like we said, people have to get paid. And so they're taking off their hard hat, sitting down at a desk somewhere and trying to get through payroll.
Right. I run into that with some of our smaller subcontractors. A lot of the work that we do may have a specialized, say, a guard or fence or a hand railing that would need to be installed. So we'll look to small contractors in Vermont because we are happy to spread the love or spread the work around. But I've had the owner of the company say, how do you expect me to go there, do the work, come home and get that payroll done? We can do the payroll, but to do this report within 7 days of an employee being paid, it's just, sometimes they just say, I just can't bid that work. I don't want to do it because I don't want to have to deal with another level of reporting. When it's, again, a small company, and if they are a sub to us on a VTrans job, they have to do that certified payroll report. I've walked through folks on it and helped to explain how it's dealt with if it's a supervisor, or how it's dealt with for people working on 3 or 4 different tasks a day. Sometimes those have to be broken out by that wage code through the day. So it ends up a larger burden for people.
Yeah, and I think it's come up, I think Rep. Charlton had mentioned, if we're reading this bill correctly, it's if a project is over $100,000 and you're subcontracting, any of your subcontractors would then also have to in turn certify their payroll, even if, like you said, their one ramp is going in on an entire project.
That's right. The only way that certified payroll requirement doesn't come into effect is if it's an owner operator or an owner that's actually doing the work themselves. And there's not a lot of single employee businesses.
Yeah.
So, I think it's just going to discourage people to want to bid on projects for the state.
I just want to say one more thing. Thank you for what you're doing. In this committee, we talk a lot about how do we encourage building. We're Vermonters, we like to keep things in Vermont, and I think we really don't want to discourage our small contractors who, in the height of a housing crisis, they're the ones on the ground doing the hard work. So I definitely have some pretty major concerns about this aspect. So thank you for coming in and answering my questions.
Sure. I think there's a lot of other rules around the state with regards to contractors and being registered and that sort of thing. I think that's sufficient to where we are right now. And again, it's a hard business to be in. And even small companies trying to bid projects right now, we don't know what materials are going to cost in 6 months. There's a lot going on the federal level that's going to trickle down to affect whether you're going to RK Miles and picking up some 2x4s or plywood. I mean, it might not be there. You just don't know.
Any other questions? You have another?
I have one last one. It's for Sarah. I'm so sorry. I should have asked it with all my other ones. You have 200 members. Do you have a breakdown of who you would consider small contractors versus the big names?
I don't have an exact number off the top of my head. I could get one for you, but just generally speaking, there are a handful, I would say, that I would consider large that I talk with often, who have, we're talking, at least 50 employees. We have some members with 200 plus employees.
Yeah.
Already, those tend to be the contractors who are working with the state. Already. And they're getting contracts that are above 200,000. It's that portal I was referring to where I pulled up that boardwalk replacement project. That's a public portal. Anybody can look through and look at open statewide contracts, construction contracts. And you'll see the numbers for yourself. I mean, we're talking at least $500,000 for most of them. And those are going to be the ones carried out by DEW, Pike, SD Ireland, et cetera. Now they may subcontract though and that's it, to your point about subcontractors. DEW themselves, and this is obviously not a knock on them. This is their job. This is what they do. They're not hanging sheetrock themselves. There is subcontracting for them. Things like that, or guardrails, as Judy was pointing out. There are lots of these kind of smaller projects or sub projects of the larger project that the large contractors are overseeing as the general contractor, but they have these smaller guys who, I mean, we're talking a handful of workers who are carrying out that work. And again, don't necessarily have a CPA on staff to be carrying out the certified payroll burden.
A question sort of following on that. You said right at the beginning of your testimony, Sarah, that sort of one fraught piece of all of this were these rather low limits of 100 or 200. Was there testimony, or did you guys consider a $500,000 limit?
I believe there's already rules around projects exceeding, and this may be a question for the commissioner when she comes up. Maybe she'll have words on this about, there are already rules in place for those $500,000 plus.
Thank you. Okay,
projects.
I look forward to that.
Yeah.
Thank you.
Thank you.
Oh, wait, Judy, you wanted to say something? You're muted.
Haven't been on a Zoom in a long time. The bill proposes that this would take effect July 1st of 2025. I think that's really important to look at. That's a lot of burden to put on a lot of small businesses in the state. And I don't know when the bill will pass, but it's the end of April. So if it doesn't pass until May, so then it's going to be implemented immediately. And these small guys are going to have to do that reporting. I think that's going to scare a lot of people. And I just don't know where the guidance is to help those small contractors.
Thank you.
So I would just add, that's also the middle of the construction season.
Yeah.
Things are rough then, boy.
I thank you very much.
Thank
I
you
have a
so much.
question for the committee. Our next witness would be Michael Harrington, the commissioner. I'm wondering, we've now been, Michael, wait. No, I'm just telling, I'm
Yeah.
about to ask
Yeah.
these guys whether
That's
they
the
want
very
to
important point.
wait. You guys want to take a break for 10 minutes? Okay, why don't we take, I apologize.
I just want to clarify one
Yeah.
quick thing that, just FYI, the 5B, which is this section that we're talking about, wouldn't take effect until July 1 of 2026,
Okay.
not this.
Okay, thank you for that clarification.
Just FYI.
Why don't we, it's now 11:15, would everyone please be back in their seats no later than 5 of 11?